All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you very much and welcome back. Mr. Nderitu, your turn next. May we get an indication as to the time you anticipate taking?
Your Honors, I don't expect to be more than half an hour or so. But I will, in any event, be well within the estimated time.
Fair enough. Just so we can know when to adjourn. Thank you. You may proceed.
Thank you, Mr. President, Your Honors. I begin this opening statement by quoting from a victim, and I quote, "The only right I had and the only mistake I made was to have been present at the scene of commission of the crime," unquote. Through this quote, Your Honors, I hope that your minds will be focused and remain focused on the fact that although the criminal case, and I emphasize criminal, is an adversarial disputation primarily between the prosecution and the defense, the justice case, and again I emphasize justice, includes victims as an integral component of the case, and so to speak, the justice case therefore has more than two sides to it. To quote the submission of the representative of the Victims' Rights Working Group at the United Nations Diplomatic Conference of Plenipotentiaries on the establishment of an international criminal court, and now chief of the Victims' Participation and Reparations section at this court, Mrs. Fiona Mackay, I quote, "There would be no justice without justice for victims, and the International Criminal Court must therefore be empowered to address these rights and needs. It would be the court's ability to bring to justice those responsible for the crimes within its jurisdiction that would do most to satisfy the expectation of victims," unquote. Your Honors, these words hold true today as they did in 1998, 4 years before the provisions of the Rome Statute came into force, paving the way for the prosecution and punishment of the most serious crimes known to man. Now, a victim of Kenya's post-election violence of 2007-2008 echoed this position in even more compelling words. And again, I quote, "If there were no victims, there would be no case. If there was no suffering, would there be any reason to accuse the accused? We are the ones who experienced the atrocities. The court sits because there were atrocities and there was pain suffered by the victims," unquote. Mr. President, Your Honors, it was not for nothing that the founders of the International Criminal Court brought victims to the center stage of the criminal justice process. It was in recognition of the fact that international justice would count for nothing if victims were not willing participants in the process of restoration of law, order, peace, and security, which had been threatened by genocide, war crimes, and crimes against humanity around the world. And it is neither the prosecutor nor the defense that was most deeply affected by the crimes before you. Now, this statement, I know, may at first glance sound unsophisticated, but in it lies the naked truth that it was the victims who bore the brunt of the crimes. They suffered emotional damage and scarring, physical damage and scarring, financial damage and social damage. Neither the prosecution nor the defense can lay claim to having suffered all these types of damage. Where I come from, there is a saying to the effect that unless you have drunk of the cup, in reference to a cup of bitter herbs which you must take as medicine, then you do not know that it is full to the brim. This saying means that it is only a person who has endured an event who truly knows the experience. In other words, while the prosecution and the defense may line up their witnesses to tell the 2007-2008 story, no one can relate the ordeal more vividly than the victims themselves. In common parlance, Your Honors, violence is an act of aggression, generally against a person who resists. Violence may also be said to be a turbulent state resulting in injuries and destruction. Both these definitions belie the real import of violence, the infliction of emotional and physical damage and shock with long-lasting effects. Your Honors, the process of becoming victims was an unwarranted and gross invasion into the self. And I borrow here from Professor Gerd Ferdinand Kirchhoff of the Graduate School of Victimology, Tokiwa University, Japan, in order to bring home this senseless, gross invasion to the self. Now, imagine an onion with its brown and tough outer peel. When you remove it, you get to more tender parts of it. These are parts that have never seen the sun, parts which are softer. The deeper you go, the softer the material. The softer the material, the more sensitive it is to intrusions. The more sensitive to intrusions, the easier it is to intrude. The less protected, the more pain is produced by the intrusions. Now, in the center of the onion lies the real self. Your Honors, this model of the peeling of the onion by Professor Kirchhoff demonstrates how, prior to the post-election violence, the victims I represent lived protected in themselves. They thought that they could themselves determine what happened to them. That, indeed, is the way we all think when our personal dignity and integrity of the self are intact. We then have a sense of self-worth. And as an aside, I may say that I know exactly what I'm talking about, being myself a survivor of the 1998 US Embassy bombing in Nairobi. Now, the victims of the violence, however, eventually ended up being exposed to the grabbing invasions of the perpetrators of the violence, and they were stripped naked to the very inner core of their self. And now, close to 6 years since the violence, these victims have continued to be stripped of their dignity and have felt and continue to feel insecure and unprotected. Insecure because they do not know if they can ever again trust their own neighbors and live among them. Unprotected because the government and its machinery have sidestepped their responsibility to bring to justice those responsible for the heinous crimes. Unprotected by a government whose very raison d'etre is to help victims. Mr. President, Your Honors, this can hardly be a way to live. People everywhere must live feeling secure and protected anywhere. They must live peacefully and meaningfully with their sense of self-worth intact. And Your Honors have the task to make this a reality. In making this a reality, it serves well to remind Your Honors that many of the victims I represent are victims of repeat victimization. In some cases, going back to the pre-election ethnic cleansing episodes of 1992 and 1997. Residents of the Rift Valley province of Kenya bore the brunt of ethnic cleansing in those two episodes, as they did yet again in 2007-2008. In the 2007-2008 episode, and as noted in the confirmation decision, the violence included hundreds of deaths, and in the Rift Valley, it was the largest share of deaths and injuries, and approximately 400,000 forcibly displaced persons. Your Honors, I have talked about earlier episodes of violence to bring into context the plight of victims who are of relevance to this particular case. They have suffered repeat victimization, not only as a result of the direct violence I have just talked about. Sadly, they are now suffering repeat victimization in a new form which is well on its way to refinement. This is as a result of subtle silencing by ethnic communities to which the victims themselves belong, and by a political reality which makes it unfashionable to bear the tag of victim and therefore to participate effectively in the criminal justice process. This repeat victimization is being further spurred by the general public and the media, and it is fashionable to hear virtually every other day that, quote, Kenyans have moved on, unquote, meaning that they have decided to abandon any avenues for justice and instead have chosen to forget the atrocities committed in 2007-2008. This begs the questions: one, who are those Kenyans who have moved on? Two, are victims of the post-election violence Kenyans? And three, have they abandoned their quest for justice? Your Honors, victims therefore need to find meaningful justice in the proceedings before this court, in which they are recognized as integral participants in the criminal justice system with effective rights, including the right that I now exercise on their behalf, which is to meaningfully participate in the proceedings, the right to an expeditious criminal justice process, as well as the right to protection from intimidation and harassment, and the eventual right to seek and obtain reparations. Short of this, Your Honors, the criminal justice process will remain faceless, where the proceedings are only between the prosecutor and the defense. This, indeed, has been the reality of most domestic criminal justice systems, and the victims I represent look up to you to counter their neglect in the criminal justice system and to usher in a truly victim-centered international criminal justice system. Honorable judges, demands for accountability from the domestic justice system by the 628 victims who are within the scope of the case, another 839 victims whose status is currently under review, and the thousands of victims of the situation whose plight fell on the deaf ears of the Kenya government and have had their rights remain unaddressed for close to 6 years now. Accordingly, it is with a measure of hope and expectation that participating victims, and through them all within the larger victim population, that they now look up to you in their search for truth and justice. They look up to you to remove from them the tag that they are the red-headed stepchild of the criminal justice process. They have traveled a long road and witnessed many attempts at scuttling the criminal justice process, including lukewarm investigations and prosecutions domestically, pleas by the Kenya government for deferral of the ICC process, threats at withdrawal from the Rome Statute by Kenya and other African states, withdrawal of victims and witnesses from the ICC process, and delays related to the commencement of the trial. The victims have many a time voiced their concerns that the trial was taking far too long to commence, and feel that through you, they can now walk along the road from, I quote, justice denied to justice restored, unquote. Mr. President, Your Honors, being a victim in Kenya today is a difficult task, emotionally, physically, socially, economically, and politically. Many victims of the post-election violence have feelings of self-blame, anger, shame, sadness, or denial, or a combination of all these. Many others are enraged by the threat to their safety and security. The emotional impact and the physical effects of victimization have come to be a symbol of disgrace or infamy. The hundreds of victims that I represent today, and many more hundreds of thousands of them who make up the total victim population arising out of the post-election violence, never expected to be victimized. They believed that a new dawn had come to Kenya, the East African country, as a result of peaceful elections that had been conducted in the year 2002. Yet, sadly, that was not to be. The events that followed the 2007 general elections dashed the hopes of the Kenyan citizenry. And as Kenyan citizens take stock of the post-election violence, many of them have, in retrospect, come to realize that they, or someone they know, was directly affected by the violence. The ravages of the violence continue to haunt virtually every Kenyan soul, as they do also threaten regional and, by extension, global peace and security. One only needs to recall the effects of the 1994 Rwanda genocide on the Democratic Republic of Congo to see how violence in one country can so significantly affect and detrimentally sow peace in another country. The violence of 2007 and 2008 affected the lives of many people, including many women, children, and the elderly. And as I make this statement, many people will no doubt recall how the violence affected and continues to affect the lives of people close and dear to them. There are many children who remain forgotten, but whose lives were drastically and brutally affected by their witnessing death, human injury, and material destruction, and other dangerous conditions that exposed them to the potentiality of harm from known and unknown sources. Many of them were disrupted at school and in their neighborhoods, and effectively compelled to move from neighborhoods and neighbors that they were familiar with to a life of living in tents, with their parents having to wait for handouts from charitable organizations and well-wishers. These child victims, along with their parents, were stripped of their sense of personal dignity. Their trust in the world, in spirituality, in deeply held beliefs about social order, justice, and humanity was fundamentally upset and replaced with cynicism, suspicion, and resentment for humanity. Through this trial, Mr. President and Your Honors bear the burden of reaffirming the international community's faith in the goodness of humankind by administering justice and thereby positively influencing the emotional recovery of the victims represented in these proceedings, including the many women and children and other vulnerable groups. It is a long road to recovery, beset by legal, political, diplomatic, and other intrigues. In short, it is by no means a light burden, but one which you must fully and effectively discharge if the victims are to achieve any meaningful measure of recovery. Honorable judges, the story and plight of the children I have just talked about, who one might refer to as children of a lesser God, is largely unknown to the criminal justice system, as children are often not given a voice to be heard by the system. But apart from physical injuries sustained by them, and indeed by many adult victims, children victims bear the brunt of victimization, and their behavior and schoolwork take the greatest impact. Not to mention inability to participate fully in proceedings. The emotional scarring to them is lifelong. These children, as indeed all other victims, have the right to be fully informed of the reasons why they had to and have had to suffer for doing what they had to do, which is simply being law-abiding. Indeed, one asks, did they have to suffer? The victims, all victims, have the right to be heard and heard in an effective rather than in a merely symbolic manner, as this court has so often pronounced. This calls for a corresponding duty on the part of the court and of all participants in these proceedings to listen to the victims. The victims need to air their emotions and tell their story after the trauma of the crimes. They are therefore expressing the hope that through the process before you, those who bear the greatest responsibility for Kenya's darkest hour will be identified and ultimately convicted. By presenting their own views and concerns to you, victims hope to have a voice in the proceedings that is independent of the prosecutor. They hope that they will assist the judges to obtain a clearer picture of what exactly happened to them and how they suffered and how they have continued to suffer, and that this will ultimately lead to having a meaningful impact on the way these proceedings are conducted and in their outcomes. As I say this, the participating victims of the case are acutely aware of the fact that the trial chamber will need to balance different interests and concerns, including the rights of the defense and the interests of a fair trial in the course of the decision-making process. The victims pray that the chamber will constantly bear in mind that without their views and concerns being effectively heard, then any talk of a fair trial will be no more than talk in the abstract. For there cannot be any concept of fairness without the concept of justice, and there can be no criminal trial without victims of the crimes charged. Your Honors, the victims participating in these proceedings, through no fault of their own, are suspected of and live in collective guilt as a result of being members of one or the other ethnic community. This collective label has seen persons who bore no responsibility whatsoever for the 2007-2008 post-election violence being labeled, I quote, members of the perpetrator community, unquote, and by extension, perpetrators of violence, by reason only that they belong to a certain ethnic community. This is one of the ugly impacts of the recurrent violence, and sadly, it appears that the bulk of the Kenyan society is yet to come to terms with the full implications of this violence. By emphasizing individual criminal responsibility, Your Honors, victims of the violence and those others who are collateral damage for being referred to as members of perpetrator communities, it is hoped that the court will bring this revisionism to an end and that the Kenyan society will become more and more tolerant. Mr. President, Your Honors, you are acutely aware that a number of witnesses have withdrawn from testifying before you. This threatens the very basis for hope of a credible justice process for the thousands of victims who suffered in 2007-2008. The victims have been concerned by these withdrawals in much the same way that they have been concerned and disturbed by claims of withdrawal by victims from participating in this process. But they are not the only ones who have been concerned and disturbed by withdrawal of witnesses from testifying in the proceedings. Both the prosecutor and the defense have repeatedly voiced the same concerns. Yet, Your Honors, the root cause for these unprecedented withdrawals is yet to be established and, if unchecked, will threaten the credibility of this trial. At another level, Your Honors, the withdrawals will make meaningless efforts by the court to address the impunity gap. And at yet another level, I hasten to warn that the withdrawals may well spell the death knell for this court and for international criminal justice as we perceive it today. Your Honors, therefore, have the noble but equally difficult task to take appropriate steps to ensure the effective investigation of both witness and victim withdrawal from the proceedings and to take appropriate consequential measures. The victims I represent are convinced that in this you will not disappoint. And that is why, Your Honors, despite all these setbacks, the victims look up to you with hope. Hope that justice will be done in this case. And as St. Augustine said, and I quote, "Hope has two beautiful daughters. Their names are anger and courage. Anger at the way things are, and courage to see that they do not remain the way they are." St. Augustine was one of the great fathers of the early Christian church. And after a dramatic conversion to Christianity, he became a bishop in North Africa. In your court, honorable judges, we have heard and seen from the prosecutor's opening statement that the 2007-2008 post-election violence, which forms the basis of a case before you today, was a grave matter, even literally speaking. So, as you listen to the evidence in your court, I beseech you to adopt anger, that daughter of hope, for it is only fitting and right that you feel angry that crimes against humanity were committed in Kenya in 2007-2008. Your Honors, justice requires that you be angry at the gross injustices meted out against innocent victims whom I represent. And here, I talk not about irrational, temperamental anger, but rather rational, tempered outrage. But Your Honors must not stop there. And so I am imploring you to also adopt courage, the other daughter of hope. Courage to ensure that never again shall violence at a scale similar to the one witnessed in 2007-2008 return to Kenya, nor indeed anywhere else in the world. Through these proceedings in your court, Your Honors have what it takes to ensure this. And Mr. President, Your Honors, as I stand here in your court, I can only say that the ball lies squarely in your court. I thank you.
Thank you very much, Mr. Nderitu. We will try not to be angry. We will keep an open mind to get to the bottom.
Well appreciated, Your Honor.
Thank you.
I talk about tempered outrage.